Thank you for coming this evening. We're going to have this wonderful session for about an hour. I hope you had a chance to partake a little bit in the reception of the goodies out front. I want to just point out that this session, which is officially titled, I want to get it right, Taking Stock, the Current Status of SEC, DOJ, and Other Government Enforcement Efforts, is sponsored obviously by the Rock Center. But before we get going, I also want to point out it is a part of the Kirkland and Ellis Law Forum. And to give you just about a minute or two of background on that, I want to introduce Professor Larry Marshall, who's going to just mention it and give a little bit of explanation. Then I'll hop up and do introductions.
Great. Thanks so much, Dan. So I just want everyone to understand the context under which we're here. 3 years ago, Kirkland and Ellis approached the law school in 2010 during a time that not a lot of law firms were actually looking for philanthropic opportunities. And said, we are committed to a presence here in California. We are committed to investing in the future through law schools, and in really an extraordinary achievement, mostly from Stanford alum and other West Coast partners, matched by the Kirkland and Ellis Foundation. The firm came in with a gift of close to $3 million to support a whole bunch of programs here at the school, and it is reflected in two specific ways externally, and one of them is this, the Kirkland and Ellis Law Forum, for which this is the inaugural event, which will bring together every year lawyers, both from within Kirkland, from without, to speak about some of the cutting-edge issues. And secondly, to create a Kirkland and Ellis Scholars Program, which recognizes the achievement of 6 first-year students each year, those who are doing the best in their section for the first semester. So on behalf of the law school, and I'm particularly double pleased because I'm now serving as a counsel as well at the firm, I'm so delighted to thank you all for what you've made happen here at Kirkland, and excited to let the games begin. So thank you.
So I have a confession to make, which is there's always these awkward moments sometimes at the beginning of these kinds of panels where I stand next to Professor Joe Grundfest and I have to run introductions, and I realize that his star shines so brightly that I really have to beef up the other intros. But I must say today is a first-time exception. He's going to go last because he's pretty good, but our panel is better. No offense, Joe. So we have a Marshall Scholar, federal judge, deputy attorney general, lacrosse captain. Oh, actually, that's just Mark Filip. So let me introduce Mark Filip is a partner at Kirkland, Chicago and Washington, D.C. offices. He leads the firm's Government Enforcement, Defense, and Internal Investigations Group. He was, of course, previously the Deputy Attorney General of the United States after being unanimously confirmed by the Senate. You have to put that in bios now when it's unanimous. That's not right? He spent 4 years as a federal judge in the U.S. District Court for the Northern District of Illinois after being confirmed again 96-0 by the Senate. This is some sort of magic sauce which you should bottle and share with others. Prior to that, he was a partner at Skadden Arps from 1999 to 2004. He is obviously an expert in the areas that I just mentioned, and he was a student member of the University Board of Trustees, which I can tell you from experience takes a certain amount of political savvy. So he comes to us very much ready to participate in the panel. Please welcome Mark Filip. Thank you very much. Not to be outdone, I'm happy to introduce the Honorable Melinda Haag, who is serving as the United States Attorney for the Northern District of California after also being unanimously confirmed by the United States Senate in 2010. She comes to us as a very experienced trial attorney with more than 26 years of prosecutorial and private sector experience. My favorite part in a bio is where they kind of list the things where they are nominated and elected to be the top, whatever. It goes on for paragraphs and paragraphs. I'm just going to pick a few of them. Law Dragon is one of the 500 leading lawyers in America, twice for the Daily Journal Top 100 Lawyers in California, and 5 years in a row, and I think it may be more than that now, top women litigators in California, and including the Lawyers Committee for Civil Rights Public Service Award in 2003. Prior to that, for 7 years, she was with Orrick and a partner there, and we have given her a day pass since she graduated from the wrong law school across the bend. Thank you. Thanks for joining us. And then I'd also like to introduce, of course, Robert Khuzami, who's a partner in Kirkland's Government and Internal Investigations Practice Group. He's well known for his time that he served as the Director of Enforcement for the U.S. Securities and Exchange Commission. Prior to that, he worked at an investment bank as Global Head of Litigation and Regulatory Investments, and then as General Counsel for the Americas from 2004 to 2009. Though a powerhouse attorney, among his many awards are several related to finance and banking, not the least of which is number 40 in the 100 most powerful people in finance in the world, named in 2012 by Worth magazine. He graduated from not this law school, but a really, really good one, Boston University. And of course, we're happy to have him. Thanks for joining us. And I can't skip Joe. I give him a hard time. Of course, he's our Securities professor extraordinaire, one of the co-founders and senior faculty for the Rock Center, and beloved by students and practitioners alike. And he did something with the SEC many years ago, some sort of
Yes, but I was only confirmed by a vote of 98-1.
Oh, wow. See, I told you. Anyway, thank you very much. I'll hand it over to Joe.
You don't want to know who the one was that had the sense.
I'm afraid. Tell us after.
Senator Proxmire.
Really? Oh.
There you go.
Thanks very much.
Good, thank you. We have an absolutely spectacular panel with us this evening, and we have some extraordinarily controversial topics that we're going to wind up addressing. And without further ado, we're going to start with Mr. Filip. We'll then move to Mr. Khuzami. We'll then move to Ms. Haag, and then I will close off. We're going to try to maintain as much time as possible. We're going to try to maintain as much time as possible for questions from the audience. I think given some of the topics we're going to touch on, there'll be a great deal of room for dialogue. And with that, by way of the briefest of introductions, Mr. Filip, the floor is yours.
Thanks a million. Thanks to everyone for coming. It's a real honor for all of us to be here at Stanford and at the Rock Center. And a special thank you to Amanda Packel and Lucy Rica for their help in helping to set this all up. A lot of great efforts and tireless work. So thank you both very, very much. I'm going to touch on briefly two topics in enforcement areas with a perspective I hope that's directed not principally to lawyers but to an audience that could, sort of a dream jury, if you will, people from all different corners of the community, some lawyers, some business folks, some directors, and so forth. And those are two areas that are probably the most important area of federal enforcement right now, with the first being the Federal Foreign Corrupt Practices Act, which is a statute that has both criminal and civil components to it. And then also, secondly, something called the False Claims Act, which is a civil statute that has enormous potency to it, and it also has a lot of analogs at the state and even municipal level, including the first state False Claims Act passed here in California about 30 years ago. Real briefly, the Foreign Corrupt Practices Act, or FCPA, in essence, and I'm oversimplifying the way you sort of always do in life, but in essence, it prohibits giving bribes, giving things of value to foreign government officials in an effort to win business. At the time it was passed, it was right in the wake of Watergate. There was a lot of controversy about whether it made sense to pass the statute or not. At that point in time, under the tax codes of many countries other than the U.S., bribes could be considered tax deductible for businesses, and so it was certainly a widespread practice in the world, and there was a view that that was a very naive thing for the U.S. to do, to try to criminalize this, that it was sort of fighting against human nature. But the view that clearly won out was that the FCPA was passed. Before I go on the FCPA, sometimes when you talk about the FCPA, it sounds very preachy because you're always talking about foreign countries and all the sort of wicked, corrupt things that people there do. I have to tell you, I've lived most of my life in the city of Chicago. There is nothing unique to foreign civilizations in terms of their ability to be mercantile about government activities. So I hope I don't sound preachy or haughty about that. But many of the actions do revolve around activities in China or Vietnam or India or other parts of the world. The FCPA has both, as stated, a criminal component. People at companies, including decision makers at companies, high-level decision makers, can go to jail if they're sanctioning, condoning, leading in a systematic way efforts to bribe foreign government officials in an effort to gain business advantage. It also critically has a substantial civil component, which the SEC, as opposed to the DOJ, enforces. And so even if without intent or knowledge, the books and records of a publicly traded, publicly listed company have been mischaracterized with respect to bribe money, there can be substantial, very, very punitive sanctions on the civil side, including disgorgement, heavy sorts of monetary sanctions. Why does any of this matter? Why is this not some obscure area that people living in the paradise of Northern California don't need to care about? For a long time after the FCPA was passed, it was quite a kind of sedentary area of the law. So even as recently as 2004, between the DOJ and the SEC, they had a combined total of 5 enforcement actions. By 2007, that number was up to 38. By 2010, 74 separate actions were brought. They have enormous consequence in terms of the dollars involved. Over $4 billion in fines and penalties were recovered over the course of the last 6 years, and some of those recoveries have been truly massive. So Siemens was the subject of a much publicized $800 million enforcement action here in the U.S. There were parallel echo sorts of suits that touched on Germany, among other countries. There was nearly a $600 million resolution against Kellogg, Brown & Root in 2009, and then a nearly $400 million resolution against the UK defense contractor BAE Systems in 2010. So this is a real spike, and this has been avowedly and loudly trumpeted as the #2 enforcement priority worldwide for the Justice Department over the course of the last 5 years or so. Now that's likely to moderate over time, not because a new attorney general, a new administration doesn't care about corruption. It's hard to stay #2 on the chart if you're anything over time. So someone might come in and they might think that violence in American cities deserves a higher priority than the Foreign Corrupt Practices Act, or whatever it might be, cyber crime, export-import crime. It's hard to stay #2, but #2 is an extraordinary spot, and it has been a real priority, and as a consequence, there's an infrastructure surrounding the prosecution of the FCPA that will be there and endure over time and will continue to make this a salient issue. It is, as stated, something that's prosecuted, enforced by the SEC, including by an SEC regional office right here in San Francisco. And it's driving the way businesses look at deals, whether they do deals, how they diligence deals, how they operate and reform, if you will, companies post-acquisition. There's almost compliance plays now where companies will buy a foreign entity, quote unquote, clean it up and sell it for a higher multiple. So it's driving a lot of corporate activity. Briefly on the False Claims Act. The False Claims Act is not a new statute. It was actually passed in the Civil War as a way to get to contractors who were selling defective sort of disease blankets, if you will, to the Union Army. And the theory was that if you give defective goods to the government, you're going to be made to disgorge your profits. It was a moribund effectively for about 130 years, and then some amendments were passed. And in the wake of those amendments in the 1980s, there's become enormous activity in the False Claims Act area. So if I talk to my former colleagues in the federal judiciary, they would tell us that the #1 growth area for large lawsuits in the federal courts are False Claims Act suits. And the reason why that's true is because it's kind of a unique statute in that they can be initiated not only by the Justice Department, although the Justice Department certainly can initiate them, but also can be initiated by whistleblowers. And there's a lot of Latin verbiage surrounding that tends to obscure more than it illuminates. But they can be initiated by whistleblowers with enormous financial recovery potential for those individuals and for the counsel, the very sophisticated counsel who've developed to try to cultivate these sort of False Claims Act suits. And we've moved far beyond disease blankets being sold to the federal government. The jurisprudence has expanded enormously into a lot of things that might not on first blush seem to be issues relating to the federal government. There's been an expansion of the jurisprudence surrounding the kind of indirect use of federal money and how that can all be subject to the False Claims Act. There's an enormous thirst for these False Claims Act at the state level. So in the False Claims Act area, you'll see literally plus or minus December 1st of every year, the Justice Department issues a press release, and it says, record year for DOJ, $4.9 billion in False Claims Act recoveries. The next year it's bigger. It's always getting bigger. So it's something that people are mindful of. And at the state level, many states have analogs on a state level. It is something that the Attorney General typically of states avowedly campaigns on. We're protecting you. We've recovered X $100 million for the good citizens of the state of Oklahoma. Vote for me. It makes the issue have a lot of immediacy to it. It can complicate the cases because if you're in the federal government and you think you have a fair settlement, but you have 50 state attorney generals who have their own view about what piece of the pie they ought to get, that can be complicated. Sometimes the governor has a different view of things. A lot of times the governor's principal and existential threat to being the next governor is the state attorney general. So they have a real problem getting to yes on that because the governor does not want to have a happy press conference by the attorney general announcing what a great job he or she's doing for the good citizens of the state of wherever. So practical consequence, in 2012, fiscal year 2012, nearly $5 billion in recoveries at the federal level. That eclipsed the former record by almost $2 billion. A total since January of 2009 of almost $14 billion. It exists in the healthcare space. It's very robust in the banking and financial services space. It exists in the technology space. Any kind of entity that's doing business with the government is going to have this potential exposure there. It is because of the whistleblower aspect to it. You'll see it initiated by private attorneys. It's a very, very important part of the legal landscape now. A couple final points. In terms of internationalization of enforcement. Enforcement is infinitely more international now than it was even 10 or 15 years ago, 20 years ago, 100 years ago when I was a young lawyer. That's partially because of technology. It is not uncommon if you were sitting at the Justice Department to talk to the folks in the FCPA unit and to hear that they got some really hot tip via an email overnight from somebody in Thailand. They were in touch with the Thai authorities. There's robust systems that are in place on an anti-corruption front, so FCPA, throughout Europe, throughout China. China is an extraordinarily aggressive system. They put people to death for corruption there. From afar, just my perception, it seems to be selectively enforced. I'm not sure that everybody who's taking bribes is being prosecuted evenly. There seems to be an aspect of competitive advantage there, but maybe that's true in other parts of the world as well. In terms of state enforcement activity, including in particular in the False Claims Act space, is going to continue to be even more aggressive, I think, in the future. So for folks who are lawyers or business folks, I think that's going to be an increasing concern. Some states almost appear to be trying to solve budget deficits through enforcement actions. People get addicted to that money. And it's hard because of the licensing requirements that exist in modern society. If you are found liable of a False Claims Act violation, you're stripped of doing business with that particular government entity. On the one hand, that's not a particularly sad or sympathetic tale. No one has a right to do business with the government, and certainly no one has the right to defraud the government. But because of the value, the economic might of that licensure, you can create an enterprise level risk for a business entity through what otherwise might be a small problem. And to have that degree of potency gives a government authority, gives a whistleblower, gives that whistleblower's lawyer a lot of leverage in negotiations. And oftentimes these resolutions happen outside of judicial settings. They're presented to judges as fait accompli, but they're not really litigated out in courts. And so it'll be interesting to see over time how the system deals with that dynamic to make sure that optimal outcomes are being reached for everyone, because it does matter immensely whether or not investors and citizens particularly of multinational companies that have choices about where capital is going to flow here versus other parts of the world, whether they do believe that the system of regulation and enforcement they're subjected to is one that is fair. That's been one of the great strengths of the American legal system over time. The story of Miami as an economic center in the world is largely a story of how the American judicial system, the American enforcement system in Miami, was perceived to be substantially stronger than in other parts of the neighboring world. And that belief itself had enormous economic consequence and benefit for South Florida, for the United States as a whole. So all these things, I think, will play out in that sort of way over time.
Rob?
Thank you. And I too am very happy to be here. I thought I'd just offer a few observations about the Securities and Exchange Commission and where it might be headed. I finished 4 years there in February of 2013, and I spent a good part of that time, seemingly in retrospect, defending against accusations that the Commission had not done enough to fight the consequences of the financial crisis. Always a certain frustrating part of the job for me, but when, more or less the entire enforcement program is being judged by whether or not you're able to prosecute, either Jamie Dimon or Lloyd Blankfein or Dick Fuld, it sort of, becomes pretty easy to evaluate how you're doing or not. But I will say that from where I sit now, there remain, somebody smarter than me, much smarter than me, I think, observed about the financial crisis that something about, the economic fallout from the financial crisis would take 5 years to remedy, and the legal fallout might take 10. But the political fallout could take 25 or 50 years in terms of the public sentiment about financial institutions and corporate America in general. And I think certainly now, only 5 or so years out, I think that the general view that that not enough aggressive enforcement has been visited upon financial institutions, banks, and others still remains very, very strong. I think that whether or not the press speaks for the public or not is always an open debate, but certainly the press, in many parts of the press, remain very aggressive about supporting more aggressive enforcement. The people who are being appointed to these jobs, I think, have a similar outlook. I mean, when Mary Jo White, former U.S. Attorney in New York, gets picked as the SEC chairman and the president introduces her as, quote, "Don't mess with Mary Jo," it gives you a little bit of a sense, not that she needs any encouragement, about what kind of enforcement philosophy she's going to bring to the job. There's a number of former prosecutors being appointed to leadership positions within the Division of Enforcement. I think a relatively stable platform, not a lot of distraction as there was that I faced. My colleague Mark Fagel, who's here in the audience as well, who ran the San Francisco SEC office for many, many years and very successfully. Some of the challenges that we faced right after the Madoff revelations in late 2008 and the financial crisis meant there was a great deal of distraction going on at the Commission. My boss, Mary Shapiro, testified 45 times over the course of 4 years in front of Congress. There were, dozens and dozens of Inspector General reports finding fault with one part of the SEC's efforts or another. A great deal of press scrutiny. That has backed off a fair degree, and so there's less, I think, distraction and more ability in the current commission to really focus on the mission. And a certain amount of congressional honeymoon, I think, going on that also is lessening the distraction. So, the current leadership, I think, is taking an aggressive view, is not distracted, and is looking for new priorities. To some degree, the agenda for the commission is, it was handed to me because it was made off in the financial crisis. It was pretty clear what needed to be done, and the same was true in past years with respect to the large accounting frauds of the early 2000s or the tech boom. But it's a little unclear as to what the current agenda is going to be, in part because the next crisis hasn't really revealed itself, And so there's, as there should be, a great deal of effort in trying to figure out sort of what the commission should be focusing its efforts on. Now, a great deal of energy is going into passing the remaining Dodd-Frank rules, because there's a great deal of work that remains to be done. But with respect to priorities, I think where I see the commission going, in terms of the substantive area, the commission has very clearly announced that it believes that accounting, fraud, and financial statement non-disclosure is an under-prosecuted area of wrongdoing in the last few years. The accounting cases used to probably be 22% of the SEC's docket historically. It dropped down to probably 12 or 13% in the years after the financial crisis. The optimists believe that Sarbanes-Oxley, the CEO and CFO certification requirements, the creation of the PCAOB, the fact that persons with real qualifications now serve on audit committees to the extent that they perhaps have not historically, or as someone put it to me the other day, Tommy Lasorda isn't on audit committees anymore. The restatements, are down significantly from the mid-2000s, and so the optimists say companies are much better at this sort of thing. They're not concealing the misconduct. They're taking the hits when they need to, and financial statements are just much cleaner than they used to be. And that's the reason why there's fewer cases. The pessimists say the incentives haven't changed at all. There's as much pressure as there's ever been, particularly as the economy picks up, to hit earnings per share numbers, and that what's really going on is they've just gotten smarter about concealing the wrongdoing. And the reasons restatements are down, for example, is because, well, you may have some losses, but you're more aggressively looking for income and revenue that you can take to offset those losses so that you don't actually have to engage in a restatement. And I think that the current commission's view is that is more toward the latter than the former, and they've started some new task forces to try and scrub public filings more closely, look for outliers, do more data analysis, trying to identify companies that appear to be outliers with respect to other industries in their sector, with respect to revenue recognition or reserves or other kind of accounting devices. So I think you can see more action in that space. Insider trading was, probably the single most successful initiative from the SEC and the Justice Department in many respects for the last few years. I think the SEC had charged over 450 people with insider trading the last few years. The U.S. Attorney's Office in New York, I think nearly 80 convictions at trial, by way of trial or plea, culminating in just last week's announcements with respect to SAC Capital. I think that'll continue to be a priority, although, a lot of this was harvested off the original wiretaps in the Galleon case, which then resulted in a number of persons coming forward and cooperating with the government, which tends to spawn a number of cases. I think at some point that gift is going to stop giving. And I think there's a natural inclination. It's always a priority area, but I think there'll be a natural inclination to want to take the view, and appropriately so, I think, that we've made our mark in this space for the time being. The deterrent message is out there and it's strong. We don't necessarily need to emphasize it quite as much as we did, or continue to give it extraordinary resource commitments. So the cases will continue to be there, but I suspect not quite at the same level. There'll always be an emphasis on prosecuting cases arising out of the new Dodd-Frank rules, and using using the enforcement tool in an attempt to make sure that there aren't abuses coming out of some of the new rules. So as the rules around permitting general solicitation in private offerings are liberalized, and companies can now advertise in a way that they couldn't before in private offerings, I think you'll see close scrutiny to make sure that advertising is not misleading, and other anti-fraud devices to make sure that companies are not abusing their newfound freedoms, in that case under the Jobs Act. And market structure and abuse continues to be a very high priority. The SEC is rightly concerned about the lack of transparency around trading platforms, high-frequency trading, algorithmic trading, and what that means. Part of the problem is simply, it's very difficult to understand exactly what the impact of some of these trading platforms are. The SEC is now, for the first time, going to be able to collect a lot of data about exactly the types of orders that are being entered, the cancellation rates, what kind of securities are being subject to certain levels of cancellation, and just trying to gather the data and the empirical evidence in order to then figure out what the market structure should look like and passing rules along those lines. But the enforcement tool will continue to be considerable, particularly with respect to trading systems that improperly use customer data for their own purposes, or, as you've seen in a number of cases, exchanges and others who don't have the technological capacity to do their job and suffering outages, which causes a great deal of investor stress and concern. So I think that'll be a priority area. A couple of quick areas to mention, not so much in substantive areas, but approaches. There's a little bit of schizophrenia about more individuals need to be prosecuted, but now, we're not afraid to charge companies or even indict companies anymore. It's sort of both ends of the spectrum are being addressed. So when I was at the SEC, of course, the charge was you should stop suing institutions and sue more individuals, of which we sued a great number, quite honestly. But and I think that continues to be a strong motivating factor. And so you saw Stevie Cohen of SAC Capital being charged on a failure to supervise theory, and I think you're going to see that theory perhaps used more and more in circumstances where it's appropriate to find ways to charge individuals. The use of negligence-based or causing violations, which are sort of the SEC's secondary theories that they can use, or theories with lower burdens of proof to cast a wider net. I think you're going to see more of that. But at the same time, I think there is a view, and Melinda can probably speak to this more than I can, but at the SEC, but also at the Justice Department with respect to that perhaps the enforcement authorities have taken too seriously the lesson of Arthur Andersen and the charges against companies, and that they shouldn't be so reluctant to charge entire companies with civil and criminal wrongdoing under the right circumstances. That's not to say it's going to happen in many cases, because everyone takes into account the impact that would have on shareholders and customers and employees. But you saw SAC Capital being charged as an institution and paying $1.8 billion fine, of which $600 million went to the SEC, so $1.2 billion in new money. I think if you listen to some folks at the Justice Department, they're not going to be quite so readily to accept the argument that companies should not suffer criminal charges, and that is obviously a very serious action to take in light of the consequences and in light of the law, which gives government enforcers a great deal of latitude to charge companies, because you can charge a company really for the act of even an individual employee, although it's not going to happen in the case of the individual employee. Obviously, SAC Capital, you had 8 people pleading guilty to criminal insider trading or being convicted at trial, so that's certainly a case where it might well have been the appropriate outcome. But I think you're going to see more activity in that area. And then the last area is admissions, which the SEC historically and most federal civil enforcement authorities did not require defendants to admit wrongdoing as part of settlements, and it's a long-standing practice. And fundamentally, it comes down to the view that given all that goes into an SEC settlement in terms of fines and charging individuals and a complaint that lays out the evidence, and the fact that they can't deny the wrongdoing and undertakings or reforms that might be part of a settlement, there's not a lot of mystery that the company or the individual engaged in wrongdoing. And so while there might not be an admission of the form that exists when you stand up in court and raise your hand and admit wrongdoing, it's pretty darn close to it. But that the costs of requiring the actual admission, that additional marginal amount of accountability, isn't worth the cost in terms of delays in bringing cases, bringing fewer cases, not being able to get money back to investors quickly enough, getting bad actors out of the industry, and the other advantages. And that's a debate that's going to continue to go on. Mary Jo has required admissions in more cases, and I think she's probably right that it's certainly established. I think it's for public accountability purposes. I think it is true that it serves a greater public accountability function. There's no substitute for standing up and admitting wrongdoing in a court or in an administrative proceeding. But at what cost will be the question, and that remains to be seen. It took a couple of lawyers, 4 to 6 months to try the Tor case, the Goldman Sachs individual charged with wrongdoing, and if the commission gets 5 or 10 or 20 more trials a year because companies are reluctant to admit wrongdoing because of the consequences, that's going to seize up some of the SEC's capability for some period of time. So that remains to be seen how that plays out. But I think that newfound effort to obtain admissions is probably here to stay for a while.
That's it. Thank you much, Rob. And with that good news, we turn to our local United States Attorney, where I trust this is the only opportunity in which you get to meet Melinda, because if you meet her outside this room, it's typically not good news.
Luckily, there's a few friendly faces in here. It has been enormously challenging to be the United States Attorney over the last couple of years because of sequestration and budget battles and government shutdowns. It's been enormously frustrating. As I say to people, I want to be the U.S. Attorney during flush times when nobody's arguing about our mission and our money and I'm allowed to hire and that kind of thing. So it's been a complicated time to be the U.S. Attorney, and there are 93 of us around the country, in addition to all of our colleagues at the Department of Justice in Washington, and we're all sort of facing these same issues. But despite that, I'm proud to say that the people in my office, the people in all the U.S. Attorney's offices at the Department of Justice continue to come to work, even when they're not being paid, which nobody was in early October. I was amazed, frankly, as I looked around the office that everybody got up, they got dressed, they drove to work, and they were all working. And it was unclear whether they would be paid, and if so, when they would be paid. But it does not deter people that do this public service. So, but despite that, there have been enormous successes, in my view, not only in this district, but around the country with respect to criminal enforcement in the white-collar space. And just to name a few examples, I like to keep track of the headlines, and if you just look over the last couple of weeks or months, there are great examples of it. The most recent one, Johnson & Johnson agreed to pay $2.2 billion to resolve criminal and civil health care fraud allegations against them. That was 3 U.S. Attorneys' offices coming together with the Department of Justice. That was my office, the Philadelphia U.S. Attorney, and the Boston U.S. Attorney's office, along with our colleagues at the department, put that case together. One trend, I would say, is that these companies that operate nationally and internationally are, I think, increasingly facing attention from more than one U.S. Attorney's office and the Department of Justice and the SEC and other regulatory agencies, and I think they find themselves dealing with a number of us at the same time. And I like to think that we can be efficient and we can work together, and it doesn't have to triple or quadruple the expense for the company in dealing with a problem. But the $2.2 billion reflects wrongdoing addressed by 3 U.S. Attorneys' offices, mine included. Of course, the LIBOR rate manipulation cases that have made the news lately, and I know Rob knows a lot about those. And as Rob referenced, the SAC Capital case, where $1.8 billion was used to resolve that, or $1.2 billion, depending. There was some criticism of that because I guess $600,000 was paid to the SEC separately and earlier. But the SAC Capital case, $1.8 billion, and the Johnson & Johnson case, $2.2 billion, was announced the same day. So in one day, depending on how you look at it, $4 billion, give or take, was paid by 2 different companies to resolve allegations of misconduct by the Department of Justice and the SEC. One frustration for us is that we pay for ourselves many hundreds of times over. And if Congress was rational, Congress would grow the Department of Justice and would grow the SEC and would grow the regulatory agencies, because my annual operating budget's about $25 million, and we bring in many times more than that. I don't get it. It doesn't come into my office. It goes back to Washington, and I have to beg and scrape for resources in my office. So it's definitely a frustration. There have been insider trading cases announced just in the last weeks and months. The former president of Qualcomm's global business operations was indicted in the Southern District of California. In my district in September, we had 2 different insider trading trials in which both of those gentlemen were convicted at the end and are awaiting sentencing. We brought criminal charges against former executives with United Commercial Bank here in San Francisco, which collapsed in 2009. That was the biggest, that's been the biggest SIGTARP, the Special Inspector General for the TARP program, where there is fraud, where there are big government programs, there is fraud, right? I think there was an article in the New York Times in the last couple of days about concern about fraud with respect to the Affordable Care Act. And the same thing happened with the TARP program. And we brought those criminal charges arising out of the failure of United Commercial Bank here. And we also recently charged the former CEO of CalPERS, as some of you may have read here, for committing fraud with respect to CalPERS, and also a placement agent that he worked with as well. So, despite the sequestration and shutdowns and budget battles and hiring freezes and all those things, we somehow manage, the people that work in these offices, the U.S. Attorney's Office Department, somehow continue to come to work and see it as a great public service, and they continue to do great things. Another sort of trend is, of course, the RMBS task force that was announced by the president in January of 2012. Resources were pushed out to the U.S. Attorney's offices and the Department of Justice. We were the beneficiary of some of those resources here in the Northern District of California, I'm happy to say, and the task force is plugging along. So it's been a little less than 2 years, and these are extraordinarily complicated cases. They require extraordinary resources to investigate and to bring, but there have been a number of them, and despite that, since the president announced it. And when the president announced it, unfortunately, it came as a surprise to most of us when he announced it. I don't know if you were surprised, but I remember I was listening to the State of the Union address on the radio as I was driving from the most northern part of my district. I was driving from Humboldt County, or I guess Del Norte's further north, but I was driving back and listening to the State of the Union address and hearing that the president was announcing the formation of the RMBS task force. So we scrambled to meet what he promised, and the task force was formed, and it's working very well together. So far, there have been 11, I believe, at last count, and Rob probably knows this better than me, I think 11 RMBS cases are public. A number remain under investigation because, as I said, they're very complicated to investigate. But there have been two brought by SDNY, my colleague in New York, Wells Fargo and Bank of America. The New York Attorney General has brought 2 cases, JP Morgan, Bear Stearns, and Credit Suisse. The SEC, Rob can correct me if I'm wrong, 4. Credit Suisse, JP Morgan, Bear Stearns, Bank of America, and RBS. Am I right on that?
Sounds about right.
Is that right? The District of Connecticut, my colleague in Connecticut, who Joe knows well, brought a case against a former Jeffrey senior trader. The Central District, of course, brought a case against S&P, which is being hotly litigated here, and a local well-known attorney, Kecker and Van Est, are defending them and raising all sorts of interesting claims and making it all very dramatic. The Western District of North Carolina brought a case against Bank of America, and there are probably, it's fair to say, there are more to come. So the RMBS task force and the work there is certainly a trend, and really and one interesting thing about it is the use of FIREA, the FIREA statute, which Joe probably knows better than anybody, was enacted in the wake of the savings and loan scandal that was going on when I was a brand new AUSA in Los Angeles, and it provides for civil penalties for mail and wire fraud if the violations affect a federally insured financial institution. So we still have to prove that same mail and wire fraud, which is interesting, but with a lower burden of proof and with the 10-year statute of limitations. So Lee Weidman, who's the civil chief in the U.S. Attorney's Office in Los Angeles, is being given credit for developing this theory of using FIREA in the RMBS space. There was a really complimentary New York Times article about him in the last few weeks. He's been around forever, and he's a very smart guy and a huge asset to the U.S. Attorney in Los Angeles. but it's the FIREA statute that everybody's looking at with respect to the RMBS task force. Just a few more points, although Mark touched on this. Healthcare fraud cases and stats, this continues to be a huge priority for all of us, the U.S. Attorney's offices and the Department of Justice. And as Mark said, nearly $5 billion recovered in under the False Claims Act in 2012, mostly in the healthcare space. So again, we pay for ourselves so many times over that Congress should grow us, not restrict us. One thing that we're dealing with in the U.S. Attorney's offices all over the country are investor fraud cases. David Fine, who is the Connecticut U.S. Attorney, and I started talking one day and realizing that we, us and our colleagues all over the country, were dealing with a huge influx of investor fraud cases. We worked with Mark Fagel when he was the head of the SEC here. We developed the data for that, and in an 18-month period, we were able to collect the data from all the U.S. Attorney's offices, and we figured out that we had cases just brought in that 18-month period that involved more than 800 investor fraud defendants. These cases reflected losses of more than $20 billion, again, just in an 18-month period, and reflected more than 100,000 victims. That was just on the Department of Justice side. Mark developed the data, and the SEC developed the data on the SEC side, and I think the numbers were even bigger for the SEC. So it's an enormous problem. It continues to be an enormous problem. The FBI, at last I checked, devotes 60% of its white-collar resources to investor fraud cases. So these are Ponzi schemes. These are people who are just trying to steal money from all kinds of vulnerable victims. The elderly are often targeted. Affinity fraud is a big problem, so people target their own communities and basically try to steal life savings, retirement savings, college savings from everybody they can get their hands on. So it's a huge issue for us. It's a huge issue for the SEC. We're spending a lot, and the FBI, and we're spending a lot of our resources on that. Just to back up to identify the priorities, I don't think it'll come as any surprise. FCPA is a huge priority. And there was a time when, as Mark knows, it was really centered in D.C., and the U.S. Attorney's offices were really not involved in it. I'm happy to say that we are, and it's probably because it just overwhelmed even the resources of D.C. It's loosened up the U.S. Attorney's offices. If there's an FCPA investigation going on in my district, and there are, we are involved in it along with the Department of Justice. We work it jointly. It's a big priority. Fraud on the market remains a big priority. We have a number of those cases under investigation. Insider trading. As I said, we just finished trials against 2 gentlemen successfully here in September. Those trials were in September, beginning of September and the very end of September. Investor fraud, as I said, healthcare fraud. Mortgage fraud remains a priority, but I think it's probably tailing off as the statute of limitations tails off from the 2008 time frame. RMBS, as I said. And then finally, just it's a little off topic, but individual culpability. I think it's fair to say that Mark's successor, Jim Cole, who's the Deputy Attorney General, it's very important to him that if individuals committed crimes, we hold individuals responsible. There's no better deterrent than going to jail, or the thought that you might go to jail. And it's an important thing to him. And in fact, if something that we're doing comes to his level, if it's a big enough case that it comes to his level and we don't have individuals identified as targets, that's the first thing he asks is, why are there no individuals? And we actually have to justify it. And I've had to have phone calls with him and memos with him explaining why it is we didn't believe that individuals should be held individually responsible, but that the company should. So it's really very important to this Department of Justice that we hold individuals responsible. Just one final thing I'll address is white-collar sentencing. And I think it may be because of the successes of the U.S. Attorney's offices and the Department of Justice in bringing criminal cases and in seeing individuals sentenced that there's now pushback. And the pushback is being led by the ABA. The ABA, of course, is funded and influenced by big law firms. And companies. I know you still sound like a bit of a government. Both of you sound like you haven't lost completely your government bent. But the ABA, of course, is influenced by large law firms, companies, the very people that we actually look at with respect to white collar cases. And the ABA proposed in September to the United States Sentencing Commission a very significant overhaul to the white-collar sentencing guidelines that govern sentencing in white-collar cases in federal court. It's a complicated overhaul that was proposed, but the bottom line, when we plugged the numbers into the proposal by the ABA, it leads to a 60 to 75% reduction in the sentences from what they would be under the current guidelines to what they would be under the ABA's proposal for the white-collar guidelines. And that's accomplished by really three different things overall. It's more, as Mark said, it's more complicated than this, but I'll boil it down. Changes to the loss table that govern, that have a lot of influence on what the sentences are in white-collar cases. A different way to calculate culpability and victim impact is the second sort of big overall topic. And then a huge loophole at the very end where if the judge determines that the offense is, quote, not otherwise serious, probation is required. So it's a significant proposal from the ABA. It would be a significant change to the white-collar sentencing. And the Sentencing Commission convened a symposium in New York in September to talk about it. So the department was very well represented. I think there were 6 or 7 U.S. attorneys that attended. I presented the department's position, which was the result of a lot of conversation among all of us about what our position would be. And the bottom line is our position was we need more information. This proposal is quite radical. It would be a very radical change in white-collar sentencing, and we need more information. So what dovetailed, so the ABA sort of approached it, I think, from the perspective of the people who would be sentenced and the companies that they're associated with and the law firms that represent them. It dovetails nicely. They probably did this on purpose, but it dovetailed nicely with a concern by some district court judges that the white-collar sentencing is too severe. And there are a couple of judges, at least in New York, who have expressed a concern about the sentencing guidelines, and I think the two came together quite nicely in front of the Sentencing Commission, and this symposium was attended by a number of judges along with representatives from the ABA and the defense community and certainly the Department of Justice. And certainly there have been cases with very significant sentences. Bernie Madoff got 150 years, Alan Stanford got 110, and there are even cases that are less famous and maybe less well known. A man in the Eastern District of Virginia, 100 years, Edward Okun, a guy in Indiana, Timothy Durham, got 50 years, and in my district, Samuel Cohen recently received a sentence of 24 years. These were all investor fraud cases, these extraordinarily long cases. These are Ponzi schemes. These are the cases where the life savings, retirement savings, college savings of sometimes wealthy people, but sometimes not wealthy people were stolen. And in those cases, interestingly, the judges did not express a lot of concern. They saw real people appear at the sentencings, real people talk about the impact on them, and the judges didn't seem to be concerned about that. Anecdotally, and this goes into where we didn't think we had enough information, our view was anecdotally that the cases that caused the judges concern are the fraud on the market cases, and that we just basically needed more information about that. I'm going to stop there because I just looked at the clock, and it's 7 o'clock.
So I'm going to try to be...
I'm going to stop.
That's great.
Go.
I'm going to try to be very brief, and what I'm going to do is focus on what I call the next shoe waiting to drop. In other words, what would I worry about if I were corporate general counsel, director of a publicly traded company, or a corporate attorney? And at the same time, what would I be salivating over if I were an SEC enforcement attorney or a plaintiff's attorney? And obviously, it's difficult to predict what the next trend is going to be, but what the heck, let me give it a shot. Have a look at the whistleblower bounty provision of the Dodd-Frank Act, which is codified in Section 21 Cap F of the Exchange Act. I'm going to summarize brutally. Basically, if a person comes to the Securities and Exchange Commission with original information about a fraud as to which the SEC was previously unaware, that individual can receive as a bounty, and in certain circumstances must receive as a bounty, 10% to 30% of the recovery that's obtained by the Securities and Exchange Commission. Now, Rob and I have had several long conversations about this, and you'll stop me if I'm ever doing violent justice. I'm sorry, if I'm ever doing violence to the actual operation of the provision. Now,
All right, stop right there.
Okay. If the tipster, all right, or the whistleblower comes to the SEC through an attorney, then that person, the tipster, can actually remain anonymous to the outside world, although at the end of the process, the SEC has to know who that person is. So in other words, to the rest of the world, you can tip, all right, on a violation of the federal securities laws. You can get 10% to 30% of the recovery that the SEC gets, all right? What's the largest recovery the SEC has received to this point?
For the whistleblower award?
No.
Oh, in general?
In general.
How much the most they've ever gotten? I don't know. You know, they got $550 million from Goldman Sachs.
So 10% of that?
$55
$5
million.
million? All right, I'm just saying. That's all. 30%?
That'd be almost $200 million.
Yeah, not bad. So the way it works, so the question is, that's how it works on paper. How has it worked in practice? We have about 2 years worth of experience, all right? And here it takes a while, in my view, for this pig to work its way through the python, because the tips come in, the SEC has to do the investigation, you then actually have to send out the Wells notice, you actually have to have the settlement. You don't pay the amount, you don't pay the bounty until you've actually got the cash in hand. So it's going to take a while for this to ramp up. We've had 6 awards to date. The largest award to date, which was recently made, was $14 million. Okay, that's real money. If you do the extrapolation, you know that the underlying award was between 10 and 30%. So that means the SEC collected something between $46 million and $140 million. All right, and $14 million was paid out to the anonymous tipper in this case. When you can make $14 million by ratting out your cheating boss, people are going to start paying attention. If you look at the total volume of tips, there's an SEC whistleblower office, and it publishes an annual report. In fiscal year 2012, which is the year for which we have the latest data, there were 2,507 tips that came into the SEC, and intriguingly for this room, 435 of those tips were from California. We are America's tipping capital, all right, under the bounty provisions of Dodd-Frank. A distant second was New York at a mere 246 tips, okay? So to the extent that people in this room want to pay attention to the intensity of tipping activity, welcome to California, all right? By the way, North Dakota, South Dakota, and Wyoming, something's wrong. There were only 2 tips, all right, in each one of those states.
Those are cows.
I was going to say it's cow tipping over there. All right, we won't go there. Now, here's where it gets really interesting, I think, for law school professors, all right, and that is the question of whether an attorney can blow the whistle on his or her own client and still collect a bounty for blowing the whistle on their own client. Yeah, I see looks of amazement in the room. Professor Marshall over here is going, what is my colleague talking about? Professor Marshall has apparently not read Part 205 of the SEC rules, which in effect allow information to be provided to the SEC, and you can actually, if you're an attorney, and you can actually collect a bounty if you're providing the information, and here I'm quoting, to rectify the consequences of a material violation by the issuer that caused, all right, past tense, or may cause substantial injury to the financial interest or property of the issuer or investors in the furtherance of which the attorney's services were used. Under the California bar, Professor Marshall, is it permissible to violate the duty of confidentiality under those circumstances? No, it's not. The SEC is at odds with California bar rules and with the California statute. The SEC is saying, if you're a California lawyer, and if you come to us with information about a past violation under certain circumstances, we will give you 10 to 30% of the money that we collect if you turn in your client. All right, that's what the SEC is saying. And you say, well, okay, well, gee, that's a violation of the California bar rules, to which my response is, well, number one, if you're going to be turning in your client, you might want to do it anonymously, okay? Are we clear, all right, on this? And if you are successfully anonymous, what's the client going to do? All right. Second, even if the client finds out that you turned the client in and you got your 10% and it's a sufficiently large amount, what's going to happen? You're going to be disbarred? Did you turn the client in so that you could make $20 million and continue in the practice of law? Or are you going to be sitting in your condo in Cabo and going, oh, here's the notice of my disbarment, okay? I'm just asking over here, you know? I'm just trying to think like a person, okay? Or you wind up turning in your client, all right, in California, and you violate the California rules on client confidentiality, and your client gets all angry at you and winds up suing you for turning him in. Could you see that trial? Yeah, I violated the federal securities laws, and I was going to get away with it, except he turned me in, okay? How far is that going to go, all right, in front of a jury? So I think what we have, oh, and by the way, there was a recent opinion by the New York City Bar where they took the position that if a lawyer in New York, where the bar rules are much more liberal in terms of the ability to provide information to others with regard to a violation, that if an attorney subject to the New York bar turned a client in consistently with New York bar rules, it would be unethical to accept the bounty, okay, because that establishes a conflict in terms of the way the attorney looks at the situation. One would argue a fortiori in California, where you actually have to violate your duty of confidentiality if you're turning in the information under Part 3 of Section 205. So as I look out over the horizon, the development that would concern me the most is the evolution of the Dodd-Frank bounty provision. As a practical matter, I think it provides an even stronger reason for corporations to pay more attention to running their internal shops, so that there's no reason for an employee to pick up the phone and to call the SEC and to try to make 10 or 30%, all right? People who run around and kind of go, well, geez, wait a minute, hold on. How do we keep, people from blowing the whistle on us? I kind of look at them and I kind of go, aren't you asking the wrong question? All right, so the question is not, how do we keep doing something wrong without having our employees turn us into the SEC? I kind of go, you're asking me the wrong question. Shouldn't the right question be, how do you run your shop so that your employees don't have a reason to pick up the phone and call the SEC to try to make 10 to 30% on whatever the commission's going to get from you when they finally figure out what it is that you've been doing wrong? But my bet is not everybody's going to walk the line, all right, that way. And and we'll see many more of these actions. $14 million is not the largest number that somebody's going to make by turning somebody into the SEC. And in my view, it's only a question of time until you get a significant award to an attorney, but it'll probably be anonymous, and there'll be all sorts of questions that can and I think should be raised about what these bounty provisions do to traditional notions of privilege and attorneys' duties of confidentiality. That's all I got. Let's turn to the audience for questions. Come out to the mic.
A question about the S&P suit. Why wasn't the SEC involved in it? And also, why was only S&P selected? I come from another rating agency, and I know that all three of the major rating agencies did basically the same thing. So it appears that by singling out S&P, that it feeds the concern that perhaps it was a retaliation for downgrading the U.S. Even though I don't believe that's true, it feeds that narrative.
Right. It's being handled in Los Angeles, so I can't pretend to know everything about it. One thing I can say with great confidence is that I'm proud to say that the Department of Justice, in my view, is not politicized, and we don't do things for political reasons. We don't single people out for political reasons. I've never heard a whiff of anything like that. I mean, it just and there are always going to be theories about why we do things when it's S&P and not others. it's probably more along the lines of it came to the attention of the U.S. Attorney's Office and the Department of Justice. They investigated it. They found that they had enough evidence to bring a case, and they did. It also may be possible that there are investigations against the others and that they're just not public yet. We can never confirm or deny when something else is going on. So, a lot of times these criticisms arise and we just have to bite our tongues. We can't, the rules don't allow us to respond. The rules don't allow us to share confidential information, grand jury information, and we just weather the criticism and weather the storm. I don't know if Rob has more to add about that with respect to the SEC.
I can't really comment on it except to say that I think, as is publicly disclosed, the SEC put a great deal of energy into investigating rating agency conduct, but it doesn't necessarily with respect to S&P, it doesn't necessarily make sense for multiple agencies to be filing the same suits against the same entity. In a world of limited resources, that may not make sense, and there may be differences in approaches or resources or remedies or other factors that can explain why one agency may go forward and file a case when others do not.
Other questions? Mr. Fagel? Mr. Fagel, down to the microphone, please. We want to capture.
Project really loud. In terms of the pressure both the SEC and DOJ have now from top down to go after individuals, and that's always been there, but it's really amped up. The reality for most of corporate America, larger entities, banks, public companies, is it's very rare that you have the one rogue actor in a room waking up saying, I'm going to break the law. There are lawyers involved, accountants involved, board members, auditors, group decisions. So is the end result you end up dinging somebody, ruining their life, hauling them in front of a court because they screwed up, even though 10 other people involved, or do you go for the low-hanging fruit, somebody who truly was culpable? How do you make individual culpability work when there really are large group decisions?
Let me put a point on the question, if I may. Or do you go after the poor schlub who sent the stupidest emails?
Who are you asking, Mark? I'll take a stab at it. With respect to individual culpability, I think the direction from the Deputy Attorney General is to bring cases against individuals if we can, although I think it's a good point that we do temper that with respect to lower level people, and we recognize the extraordinary consequences of bringing a criminal case against anybody. It's unbelievably serious. It does result in people going to jail, some people going to jail for a very long time. So we take that extraordinarily seriously. So if we find that there are people who technically broke the law sort of at the lower levels, but they're really at the lower levels and they are working at the direction of other people, we certainly have and continue to give passes to people like that. We'd rather have their cooperation, for example. We'll offer them an opportunity to cooperate, or we'll simply give them a pass if they're at a certain level. If we identify criminal intent and criminal conduct at the higher levels, we'll bring those cases. But if we don't, we won't. And that's always the bottom line. When do we bring criminal charges against individuals? When the evidence supports it, and not otherwise. So, it's obviously a burden that we take quite seriously. We don't want to bring criminal cases against people if it's not appropriate, if they haven't committed a crime, if we don't have the evidence to achieve a conviction. So it's very case specific, very fact specific. But I feel, despite the fact the Attorney General would like us to bring criminal cases against individuals, I don't feel pressure to do so unless the evidence supports it and unless it's appropriate.
Other questions? We've got one more here.
Yeah, I had a question in regard to the Dodd-Frank whistleblower that Professor Grundfest was addressing, but this is addressed specifically at anyone, especially the people in private practice. So, Professor, you say that people are asking the wrong questions. If they're saying, well, is this going to lead to some sort of thing where the people at top you're calling out your cheating boss, and they're asking the wrong question if they're asking whether the employee should be doing that. I feel like that's not necessarily true, because we could end up with some sort of kind of inverse McCarthyism where we get like these vengeful claims or claims over minor slip-ups, claims from random people on the far left who are just anti-corporations. And like in general, I think like American culture, we don't take kindly to whistleblowers. I mean, Snowden wasn't exactly like heralded as a hero. I mean, some people think so, but not everyone. And basically, is this the kind of work environment we want to be fostering? And I mean, maybe especially the people who are in private practice right now, would you feel comfortable with your companies operating in this kind of hostile environment where you could have random people at any time blowing the whistle on your clients?
Well, I actually think the whistleblower statute passed by Dodd-Frank is actually, on balance, a pretty well-crafted rule. Congress passed the statute, and so the SEC had no choice but to write a rule and implement the program. And, I mean, we can go into great detail about it, but a couple things. One, the SEC recognized that the last thing it wants to do is sort of undercut compliance programs, control functions, and others in corporate America who really are kind of the first line of defense in stopping fraud. And so it wrote into the rule a bunch of incentives to require people, not to require people, but to incentivize them to first go in-house. And I think the anecdotal evidence from the whistleblower complaints that have been filed suggest that a significant majority of the people do first go in-house and raise to their own bosses the problem, presumably because they're motivated by a desire to simply to correct the problem. And the same numbers were true for the False Claims Act cases. There was a study that showed, I think, from 05 to 10, give or take, almost 90% of the people went in-house first. So despite the cynical view of human nature that my learned friend on the left shows, it seems that human nature for the optimists win this one a little because they're going in-house first. Now, having said that, but second of all, I mean, look, taking the step to become a whistleblower is a huge undertaking. There's no guarantee there's a payday at the end of this thing, right? In fact, there's an active plaintiff's bar who will tell and advise you if you want to be a whistleblower it's a long, hard road. You're putting your career on the line. There's no guarantee of any payday at the end of it. You're going to be ostracized from your workplace and maybe even your industry. So it takes, a lot to take that step. What I do think is a challenge to the statute, which is a problem in the statute, is not so much the fact that you get people who are out for corporate America who are going to bring frivolous complaints, because at the end of the day, the SEC will look at it and they're going to throw it out because they're not going to chase complaints just because they're raised by a whistleblower. They have got limited resources. They want to bring cases. If it's a crappy complaint, they're not going to deal with it. The one area that is difficult, I think, is the retaliation provisions, which provide that a company can't retaliate against a whistleblower in a whole lot of respects, including the terms of their employment. And that's difficult because whistleblowers they're a mixed lot. I mean, when I worked at a large financial institution, and every March, like clockwork, when bonuses were paid and promotions were given out and people didn't get the bonus that they hoped for, they didn't get the promotion they wanted, the whistleblower complaints would spike through the roof. And a lot of, and it's just kind of human nature. And so you have to work your way through that. And it's very difficult to tell a company, if you've got a poor performer who raises a frivolous whistleblower complaint, they've got to carry that person for 3 months or 6 months or a year, however long it takes. And that's a tension that I'm not sure there's any real solution for, because if you want to have a whistleblower program and you think there's advantages to it, then that may just have to be the cost of implementing it. So I don't quite see the hazards that you identify. I think the natural forces are going to weed that stuff out.
Thank you.
One last question.
I had a quick question on your presentation. I should call you Honorable Ms. Haag. You mentioned that the FIREA statute gave you a longer statute of limitations. My question is, in view of the fact that you're talking about the problem with 5-year statute of limitations on some of the real estate fraud, I mean, I would assume you could easily show that TARP and a whole bunch of other hundreds of billions of dollars got spent because of the, and there was harm to the federal banking system per se. Not to have you tip us as to your future litigation strategy, but have you considered that perhaps this is an outgrowth, that there might be application of that theory to other other statutes such as the real estate frauds issues?
Nobody wants to depend on a 10-year statute of limitations. In a perfect world, something happens, we address it quickly, we bring any cases in that space more quickly. FIREA allows us to continue to look at things that happened in 2008 and 2009 as it happens, but that's not an ideal world at all. I wasn't the U.S. attorney in 2008 or 2009. In a more perfect world, all the U.S. attorneys, the Department of Justice, everybody would have jumped on this more quickly, and we wouldn't be relying on a 10-year statute of limitations. So I'm not at all saying that it's an ideal thing. It just allows us to continue to look at it.
Because these are particularly difficult cases. I mean, you have a lot of different claims. Obviously, the pools, where the way they chopped them up and sold them in the pools,
Very
makes
complicated.
it much more difficult to trace. So I would think you could show, in a certain degree, that there are facts here which would allow you to try to use that, bootstrap yourself into that type of theory.
Yeah. If there are other options, we will take them.
One last question, Professor Ballasone.
One quick comment. For those of you who want a case study in what it's like to be a whistleblower, Google Michael Winston, who was the whistleblower technically at Bank of America, which was where the litigation took place over behavior at Countrywide Mortgage. And I think it'll give you a different perspective. Mark, my one comment about, and I know you're a defense bar guy, that corruption and is not a victimless crime. So bribery, whether it takes place in Chicago or in China, I think really needs to be taken seriously because it is a crime, because there are victims. That's my only comment.
Oh, I agree with you. I hope I didn't convey that contrary impression. I became a federal prosecutor. I became a lawyer. I have lots of people in my family who work in tool and die shops. I got people who've done a whole variety of things. No other lawyers. I became a lawyer because when I was a young person in Chicago, there was a prosecution effort called Operation Greylord. And it was a real stain on Chicago history, but there was endemic corruption in the state judicial system of Cook County, Illinois, to the point where kids like me in neighborhoods where there weren't lawyers knew that if you got caught with a DUI, that was probably $500. If you caught with an aggravated assault, that was probably going to be $1,200. And so that's why I became a lawyer, and in some ways have never really grown beyond being a political corruption prosecutor, which is what I did for the first 5 years of my career. So I hope I didn't convey the idea that corruption is a victimless crime. I actually think in a lot of ways it's corrosive to entire communities and their business and political structures.
If you haven't read it, there's an incredible New York Times story about Walmart. Walmart in Mexico, and it's stunning what's described in the New York Times.
Ladies and gentlemen, big round of applause for our panelists. They've been terrific.